Welcome to the Syndication Closer with Dugan Kelley. We all know that navigating the legal complexities of real estate syndication can be overwhelming. In each episode, we'll provide expert legal analysis, tips, and strategies to help real estate syndicators stay compliant and avoid pitfalls. This show is for anyone involved in real estate syndication, including sponsors, investors, attorneys, and other industry professionals who want to stay up to date on the latest legal developments and best practices.
Welcome to the Syndication Closers. I'm James Frazee. I'm here with Dugan Kelley, principal partner of Kelley Clark PC. And Dugan, we've been talking about what a new syndicator or a new real estate investor can expect when they come through our doors, things on the security side. And now today on this episode, I want to focus a little more on the acquisition side.
Right.
We get plenty of clients who come through our doors, and they have the very similar situation that, okay, I've got a letter of intent. I found a property that I want to buy. Now what do I do?
Love it. So this is what we would call the beauty contest portion of the transaction. So oftentimes when you're looking to buy a property, there are other people that are also trying to buy that same piece of property. The way that you're trying to tie that property up is through submitting what we call an LOI or letter of intent. Oftentimes that is a non-binding description of essentially what the terms are that you hope to see as a buyer in the upcoming purchase and sale agreement, or PSA for short. And so we're constantly helping clients navigate that beauty contest portion of the transaction, right? So before you even sell securities, you actually have to get a property accepted. Your LOI has to be accepted by the seller. Sometimes the seller won't countersign your letter of intent, but it's very important that you as the buyer understand how vital a properly crafted letter of intent really is, where you're able to describe essentially all the material terms that you expect to see in the purchase and sale agreement. Not every term is going to be in the letter of intent because these are often short and punchy, maybe 1 to 2 pages in length, but it's like bullet points, kind of like headings of what you hope to see. And so assume, right, you're a successful buyer. You've won that beauty contest. The commercial real estate broker has called you up and said, "Hey, congratulations! Your letter of intent has been accepted by the seller. We want you to know that the next step is going to be basically that negotiation process, which can often be very lengthy or very short for negotiating that PSA." And oftentimes, certainly when we're representing buyers, we will see purchase and sale agreements drafted by the seller's counsel. If you're a buyer or a buyer's counsel, you want to be the one that initially drafts that purchase and sale agreement. If you're a seller or seller's counsel, you want to be the one that initially drafts that first draft because of all the various pinch points and stakes and territory of the various terms are maintained and kind of staked out initially during that process. But it's very important for you to understand that once your LOI is accepted, you're going to have to switch into a negotiation mode, and your lawyer should really be assisting you in drafting or counter drafting and making changes and showing the various changes that exist each round of negotiations that exist between the purchase and sale agreement to ultimately, hopefully, a purchase and sale agreement that you would want to sign as a potential buyer.
And that's a very important point that you bring up, is that we have had in the past some clients come through our door where they have actually started that PSA negotiation process or tried to do it themselves, and the results have been mixed at best.
Yeah, it's net. I mean, so when you're buying large assets, whether it's raw land, self storage, mobile home parks, apartment buildings, pieces of real property that cost millions of dollars, you're doing that through a customized, negotiated contract. That process is the purchase and sale agreement process. So oftentimes I'll be talking to people and they'll say, well, I got a contract over the internet, or I just bought one, or I used the local real estate contract, or the commercial realtor brokers have their own preferred form that they want to use. Those those prefabricated forms often do not have essential components that either you as a seller or you as a buyer want to see in your contracts. And so it's very important that you not just kind of like gloss over that whole negotiation process of a purchase and sale agreement, because if everything goes great, then fine, then there's no harm, no foul. But but oftentimes there's going to be a little hair. There's a little hair on every deal. I've never seen a deal in 20 some years of practice, thousands of transactions. I've never seen one just be just magically perfect without any questions or any hair or any hurdles. And that it's at that point that you really want to know and believe and trust that your purchase and sale agreement really is going to be able to defend and back up your position as a buyer or as a seller regarding that. And you don't want to just trust it to like some prefabricated form. That's my opinion, certainly in connection with the transactions that we handle.
It's like the old saw about Murphy's Law. Anything that can go wrong will, and very often at the worst possible times. Let's talk about some of those pain points, though. What should a prospective buyer be looking for, especially when they're in the process of negotiating the final PSA?
Yeah, that's a great question, James. We're asked this by clients all the time to say, well, what sections should I really be focused in on, right? Because these purchase and sale agreements can really be really dense. Like I've seen some that are 80, 90 pages long. On average, they're somewhere between 20 to 40 pages long, but they can be less and more depending on the size of the asset, sometimes the level of sophistication of the party that initially drafted the purchase and sale agreement. And so some of the key terms that I am looking for on the buyer side all the time is, one, I want to remember what are the material terms that I included in that letter of intent to make sure that they actually match up in the PSA. You would be surprised, you might be surprised to know that a lot of times the first draft of the purchase and sale agreement that we receive from the opposing counsel, if we don't draft it first, often doesn't match the terms that were actually included in the letter of intent, whether it's the amount of money, the purchase price, the closing timeline, the amount of documents that are going to be exchanged, or the timing of the exchanging of due diligence documents, whether there was early access, meaning does the buyer or the buyer's group get access to the property prior to the earnest money going hard, whether the earnest money is going to be hard or not, and those various issues. So matching up the LOI to the ultimate, the terms in the LOI to the PSA is often what we do first. And then we want to look at what types of representations, and warranties is the seller actually making in connection with the property due diligence that they're going to be sending to us as the buyer's team, as well as the overall financial performance of the property and just state of the property. And so you want to understand as a buyer that most of these transactions are what we would call as is, meaning the seller is not making any specific representations about the performance of the property, the status of the property, the suitability of the property, unless it is contained within the purchase and sale agreement, and specifically the representations and warranties made by the seller. So that's why we tune in so closely into what the seller is actually representing and warranting. And then we add to make sure to level set this expectation that sellers always want the transaction to be as is, make virtually no representations or warranties to the buyer. The buyers want a lot of representations and warranties about the property, about the documents that were sent, about everything associated with the property. And so it's through that negotiation process that we're getting to a point where we can kind of have a level set expectation. So remember, matching LOI with PSA. We want to look at reps and warranties, and then we want to take a look at other things like prorations, right? How are taxes, utilities, other costs associated with the property, delinquent rents, other types of fees and allocation of income and expenses. How are those being treated? Those are three of the top things. And then we want to look for obviously fees, like who's going to be paying for title and for survey, who is selecting title. Is there a real estate broker? Who is paying for the real estate broker and what amount? What is set forth in the purchase and sale agreement? These are all little things that are very important for you as a buyer to understand as you're going through that, and your lawyer to explain to you those various pinch points that exist in the purchase and sale agreement. And oftentimes, you there are things that the buyer's hoping is included in the purchase and sale agreement, and if they use a prefabricated form, oftentimes will be missed because you have to actually add them as an addendum to those prefabricated forms. So even if you're a buyer and you're being forced into a prefabricated form in the transaction, because that's either what the realtor or the broker or the seller or the seller's counsel is requiring for the transaction, that's fine. What we will do is help you negotiate that prefabricated form and adding through the use of addendums and other things to make sure that all of the provisions that are necessary to protect you or your interests for your acquisition are actually included in there.
One other thing I want to talk about with the process of getting to a final PSA is earnest money. This is sort of a good faith amount that the buyer will oftentimes put up and will be held in escrow by a title company. But there's a lot of terms and conditions surrounding even that. Can you talk with us a little bit about this? Because earnest money, it's not chump change. It's a lot of dough being put on the line.
Totally. I mean, we're talking about typically in most of our transactions, we're talking about hundreds of thousands of dollars. Sometimes it can be over $1 million of earnest money that is being deposited with either the title company or the escrow officer. Depending on where the property is being sold, it can often be deposited into an escrow account. And it's very important for you as a buyer to understand exactly the refundability portion or the events that can trigger refundability of that earnest money, or whether that earnest money is hard, meaning non-refundable on day one. And so there are scores of lawsuits out there between parties who, on the one party had one idea about what the earnest money, when it should be refunded, and the other party had another idea about when the earnest money should be refunded. So it's very important for you to always have a firm or a clear understanding. Now, does that mean that the title officer or the escrow officer will automatically release the earnest money back to you as the buyer if you terminate the contract, even if the contract says that you get the money back, even if it says that it's refundable within this and it doesn't go hard until after the expiration of the due diligence date or the inspection period or the approval period? Those terms are often used synonymously with one another. And the answer is no, it's not. Why? Because the title company or the escrow officer is a third party neutral observer in these transactions. They're not meant to advocate on behalf of either the seller or the buyer. And so if you have one party that's objecting to the release of that earnest money, even if in our opinion that would be bad faith, even if they're taking a position that is erroneous, even if they've fabricated that position out of whole cloth, the reality is that the title company is not allowed to release that earnest money over the objection of that. And so we will assist clients in that process. And if for whatever reason the title company or the escrow officer refuses to release that money, ultimately there are mechanisms in the law that allow through the use of litigation the ability to have that earnest money released and dispersed to the party from whom it is owed. But it's a very, very important point that James brought up about whether the earnest money is hard and whether you understand what circumstances it can become refundable again, and how to utilize those inside of your purchase and sale agreement.
And it's very important, ladies and gentlemen, that you don't reach out to us when it's already happened. Reach out to us beforehand so that we can possibly smooth out or help you smooth out any potential roadblocks that may come up in the road to ownership. And speaking of which, if you do need help with a letter of intent, we ask you to please subscribe and like our podcast on the video side. Like, subscribe, and leave a 5-star review on the audio portion. And visit us online at syndicationcloser.com. We have a special free gift of Kelley Clark's Road to Ownership. It doesn't have to be perilous. You can tap into the power of our signature Syndication Navigation System, designed to effectively guide you beyond all the hangups and roadblocks that may get in the way of safely and efficiently closing your deal. We've got an overview of our 10-step proprietary system at syndicationcloser.com. It's a 10-part video series that's also included where we walk you down the road to ownership step by step, and we can help you get the exact help that you as a syndicator need to get past those 10 major roadblocks to closing the deal. Instant access to that roadmap is available by clicking the link in the show description or going online to syndicationcloser.com. That is syndicationcloser.com. Coming up in our next episode, we'll talk more about due diligence and what comes after the PSA is signed.
Thanks for listening to the Syndication Closer with Dugan Kelley. Follow us on social media and visit our website, syndicationcloser.com, so you don't miss an episode. Just click the links in the show notes. And if you enjoyed this episode, let us know by leaving us a review. We'll see you next time.